Well, good afternoon. It's Friday, January 16th, and this is the conclusion of the first week of the legislative session for 2015. Today, this YouTube program is the first of what will follow every week until the legislature finishes. And there's not a lot of action up there so far. These are, blue are the House and yellow are the Senate. Those are the pre-filed bills. I'll be spending the nice 3-day weekend working through all of those. Hot issues I anticipate this year. There's going to be a lot of interest in the juvenile justice revision, which is what we did for the adults 2 years ago in Senate Bill 70. Now the governor and the Chief Justice in support are going to look to do what they can to improve juvenile justice. Another hot item is going to be taxes that would be dedicated toward road maintenance and improvement. The governor's proposing $50 million. Senator Valley is championing $100 million. So there'll be, anytime it's money in South Dakota, that makes it a hot issue. Finally, Common Core in the educational area will be, again, a source of major debate. Fortunately, in all three of those, we don't have a dog in that fight, so this is more of an informational. The State Bar is proposing 5 bills. They have not come out yet. I'm circulating to get sponsor sign-ups. The first bill relates to voting trusts and agreements, and it's a simple cleanup where the voting trust agreement itself, under current law, says 10 years, and now we're going to require that the agreement have a date certain. But it grandfathers in the previous ones. That came from the Business Law Committee and was approved in June. Second bill to revise 25.7 6.27. Last session, with very hard work and a lot of cooperation, the legislature passed and the governor signed a shared parenting agreement. One of the things that was not caught immediately was that the court retains in a shared parenting the right to interpret and apply the cross credits. That current statute simply says if the parties agree. That's inconsistent now with the power of the court upon request in a trial to determine that in fact over the objections of one parent that shared parenting would work. So this clarifies that if the court so orders, the court can then consider and determine the applicability of the cross credit. That was approved conceptually at the annual meeting, and the Family Law Committee finished their draft in November. It was submitted to the Bar Commissioners and they approved it. The third bill relates to transferable interests in limited liability partnerships. By way of history, a few years ago, the Business Law Committee brought us a bill that for LLCs where a beneficial owner has a judgment obtained against them, and if their primary asset is going to be their interest in the LLC, the remaining owners obviously have an interest in not having the business disrupted and so forth. So several years ago, we directed to protect creditors' rights, but also protect the remaining business owners, that the creditor had to go and get a charging order from the circuit court, which essentially limits the ability of the creditor to those monetary distributions that would otherwise come to the judgment debtor. The Business Law Committee studied that. It's worked well the last few years, and so this bill would extend the same creditor protection and right of beneficial holders to limited liability partnerships. This big bill will get the prize, although there is no prize actually awarded, for the longest and perhaps most complex bill of the session. In 2008, the American Bar Association, after many years of work, approved a model act for nonprofit corporations. That was done in 2008. In 2009 or 2010, our Business Law Committee undertook the project of reviewing the Model Act with the existing statute, and it's been 40 or 50 years since our legislature has made a comprehensive review of those nonprofit corporation laws. So after 4 years, this is their work product, and that was submitted at the annual meeting, and it was approved unanimously. It will gather a lot of attention because there are an awful lot of nonprofits out there. I don't know of opponents yet, but certainly those that have run on a shoelace, meaning they don't hold meetings, they don't keep minutes and so forth. This bill, if it's approved, is going to require more transparency and more, call it, formal action in a corporate sense. And I have a lot of reading to do this weekend. I've got to educate myself. A bill that size intimidates legislators and frankly intimidates me. So I've got a lot of learning to do between now and next week. The last bill, and I can show you the rough draft. I haven't gotten it from LRC yet. Many years ago, 33 years ago, when I was 23 years ago, pardon me, I'm not that old. 23 years ago, we had many lawyers complaining, whether you were plaintiff or defense, didn't make any difference. They were complaining about the cost of medical records that ultimately are borne by the patient. And so in 1992, we got together and had the legislature enact 36-2-16. And the existing statute essentially says that it's supposed to be the actual cost of getting the records and reproducing them and providing them to the patient or their agent, which in many cases, as far as we're concerned, is the lawyer. In Title 62, well, it's not in Title 62, but Department of Labor adopted a rule that limited the cost of medical records in work comp cases to, and I want to say it was $10 for the first 10 pages and 33 cents a copy per page after that. And then there's another statute that deals with the hospitals and clinics, and that's Title 34, Chapter 12. So what this bill does is it's going to say several things. One, the max that you can charge is $10 for the first 10 pages, 25 cents a page thereafter. But it goes a little farther than that, because we know that virtually every clinic, hospital, doctor's office is moving to digital records. And there isn't any cost to, there's virtually nil cost on punching a button and having it download onto a disk. And in fact, the federal legislation is out ahead of us, encouraging that medical records be kept digitally, so that the patient has portability. That if they need to go to a different city to see a specialist, they press a button and they can email those test results and medical records. And there's some federal legislation that limits those costs. That would be the Health Information Technology for Economic and Clinical Health Act. That's a mouthful. But as long as we were doing that, we thought we'd also put the same restriction in, maximum, in workers' comp and also on the hospitals and clinics. So what we're looking for is to put a cap in that is federally mandated wherever it is a federally defined healthcare provider. And that's applicable federal law, and they're already doing it, or supposed to be doing it, so this says it's the lower of the two. And then, and of course, for those places that are going to still do it in the old paper format, standing by a copy machine, then it's the $10.25 a page limitation. Those are our 5 bills. Obviously, every session we play a lot of defense where we try to identify those things, those issues or bills that are of interest to all of you, my members, and where either the bar commissioners think that the bill ought to be killed, or to the extent that we can amend the bills to remove our concerns. As I've explained in previous years when we do this, I'm in virtually constant contact with your Board of Bar Commissioners. Those are the people that you elected to represent you when in between annual meetings. And so every bill that comes up that may be of concern, I email the bar commissioners, I get their direction, and we take it from there. On occasion it might necessitate a conference call, but most of it is done by email, simply because things move so fast up here that the turnaround time can be as short as 24 hours, where we need to know exactly where we're going to be. It's a long weekend. I hope you all have a great weekend. The weather warmed up, and that's a nice treat after late December and early January. You have a good one.